Let's go right to our topic of the week, and what we're talking about are some of the changes that many people don't understand or aren't aware of in the workers' compensation laws in the state of Kansas with respect to future medical care. You have heard me say perhaps on this show a number of times that in work-related injury accidents, workers' compensation claims, you have a right to medical care, and you can keep that right to medical care open if you so choose for the life of the injury. And many people suffer injuries that heal and don't need any future medical care, but just as many, if not more, suffer injuries that have a profound lifelong effect and periodically need doctor's reviews, doctor's visits, medicine, physical therapy, and sometimes even surgeries long after they were initially treated from the work-related injury. And that's what we refer to as the future medical right in the workers' compensation laws of the state of Kansas. For many years, as long as I've been practicing, and probably for many years prior to that, medical care was left open indefinitely and for what we call the life of the injury. As long as you're able to prove the need for medical care relates back to the original injury or is a natural and foreseeable consequence of that original accident injury, then you could obtain medical care. Now, effective May 15, 2011, if you're injured after that date, your medical care is limited. First off, there is a hurdle placed in your way once a doctor says you reach maximum medical improvement. You will then and now have to prove that you have a need for additional medical care as a necessity. What that means is basically now, as opposed to the old law, when you reach maximum medical improvement, medical can be terminated even if you are still in active treatment for things such as pain management, medication, and so on. And you have to prove, you now have the burden of proof of necessity. So I said it can be terminated. It may not be if it's real obvious that you have that necessity, but now the legislature, this is the one of the biggest changes. The legislature has given the employer and its insurance carrier the right to terminate medical care upon reaching maximum medical improvement, MMI. You'll hear that if you talk to a work comp lawyer quite frequently, and that will result in a slow down in your process, require you go back to a hearing if you need additional medical treatment, and present that matter to an administrative law judge if it's not agreed upon. The second big change in the requirements under the Workers' Compensation Act for injuries after May 15, 2011 is that when you go to a hearing, you must put on some proof of a need for future medical care is more probably than not, more likely than not, present in your case. In the past, you didn't have to put on any medical evidence. You didn't have to have a doctor testify or other healthcare provider testify as to the need for future medical care. It was left open, as I said, for the life, as I've always been saying, for the life of the injury. Now, under the current state of workers' compensation law, you can have your medical terminated if you don't put on some medical evidence in your case when you are litigating it to a final conclusion or when you are trying to settle your workers' compensation claim. If there's an agreement, you want to make sure that you get an agreement with the insurance carrier that medical care is necessary if that is the case, and put that into the award or settlement document or friendly settlement hearing. The third major change that's made about future medical care is that if you don't use your medical provision of the Workers' Compensation Act for injuries after May 15, 2011, within 2 years of the date that you get an award or a settlement with that medical left open, If you don't use the medical care for 2 years, then the medical can be closed out. So this new act, new provision of the law is going to require that you have regular medical appointments, at least as frequently as once every 2 years, or some use of medical treatment, or your workers' compensation insurance carrier for your employer for your particular workers' compensation case can close out the right to medical care.